Right now, not yesterday, not in some theoretical future scenario. Right now, as you're watching this. A military AI system somewhere on this planet is processing sensor data, satellite imagery, signals intercepts, behavioral patterns drawn from mobile device metadata, and it is producing a list. The list contains names or coordinates or both. Someone or perhaps no one will act on that list within the next hour. So here is what I need you to understand before this series goes one frame further. The laws governing that decision, the laws that were supposed to govern it, were written in 1945. Before the transistor, before the integrated circuit, before machine learning, before any of the technologies that are running warfare in 2026, that's today, were even theoretically conceivable. That gap between 1945 and now is not a policy gap. It is not a diplomatic gap. It is not a gap that a better UN Security Council resolution would close. It is a structural gap, a gap between what international law assumes reality is and what reality actually is. And it is the most consequential legal crisis of our time. Welcome to the AI Law. This is the Algorithmic Warfare series, and this episode 0 is your complete map of what comes next. 20 episodes, 20 fault lines where AI warfare and international law collide. Each one more consequential than the last. Each one examined with the depth and precision that this subject has, in my assessment, never fully received. So by the time you finish this episode, you will understand the entire architecture of the problem. You will understand why the law is failing. You will understand exactly which doctrines are breaking and exactly how they are breaking. And you will never watch a news report about a drone strike, a cyber attack, or an autonomous weapons deployment the same way again. That is a promise of this series. Let me show you the map. I want to begin with something unusual today. I want to begin with honesty about what the series is and what it is not. This series is not a political commentary on any government, any military alliance, or any state currently engaged in armed conflict. I'm not prosecuting any political position. I'm not defending any. This series is not a technology review. I'm not going to tell you which AI systems is more dangerous or more capable than another. I'm going to examine what specific categories of AI capability do to specific legal doctrines, and why that collision produces legal consequences that none of the architects of those doctrines anticipated. And this series is not a prediction. I will not tell you how any of the current conflicts end. I will tell you something more consequential, what the laws governing those conflicts can and cannot do, and why that matters for every person on this planet, including people who are not parties to any conflict, including people who have never heard of international humanitarian law, and including people who believe that the law of armed conflict is someone else's problem. It's not someone else's problem. Here's why. International law is the architecture of the world order. Not a perfect architecture, not an always enforced architecture, but the framework within which states they justify their actions, within which accountability is claimed or deflected, within which the difference between a war crime and a legitimate military operation is legally determined. So when that architecture fails, when its foundational assumptions are no longer compatible with the operational reality of warfare, the consequences are not abstract. They are measured in civilian lives, in critical infrastructure destroyed without legal consequence, in accountability vacuums that enable conduct no state would publicly defend. Now, here is the convergence that makes this series necessary. International law, as it governs warfare, rests on three foundational assumptions. I'm going to state them clearly because the entire series turns on them. Assumption 1. States are the primary actors. States have governments. Governments make decisions. Those decisions can be attributed, traced to a command authority, a political leadership, a legal person that international law can hold responsible. This assumption underlines every doctrine in the law of armed conflict, from Article 2, Clause 4 of the UN Charter to the attribution rules of the ILC's 2001 Articles on State Responsibility. Assumption 2. Force is physically legible. You can see a kinetic strike. You can measure the damage. You can trace the weapon system to the military unit that deployed it, to the commander who authorized it, to the state whose forces conducted it. The causal chain from decision to damage is, in principle, traceable. This traceability is the precondition for accountability. Assumption 3. Human beings make the legally significant decisions. At every node in the conduct of hostilities that law considers significant, the decision to classify a target as a military objective, the decision to authorize a strike, the proportionality assessment, the assessment of precautions in attack, there is a human being exercising judgment. That human being is the subject of legal accountability. They can be commended, they can be prosecuted, they can be held responsible before a court. All three of these assumptions are now under simultaneous structural assault. Not by bad actors deliberately circumventing the law, although that also happens, but by the nature of the technologies themselves. AI operates at speeds that are incompatible with human deliberation cycles. It produces outputs through processes that are opaque even to their designers. It is deployed by state and non-state actors alike, by governments and corporations, by military commands and private contractors, by established nuclear powers and non-state armed groups operating from territory they do not legally control. It operates across physical, cyber, cognitive domains simultaneously, often producing effects in all three at the same time through a single algorithmic operation. And it generates harm, kinetic harm, economic harm, informational harm that cannot always be traced to a single command decision by a single accountable human being. Paul Scare, who spent years working on autonomous weapons policy within the United States Department of Defense, and whose 2018 book, Army of None, it remains the most rigorous single-volume treatment of autonomous weapons available. Described this as the third revolution in warfare after gunpowder and nuclear weapons. He is right about its scale, but I want to add one thing to Scare's framing. Unlike gunpowder and nuclear weapons, which expanded the physical scale of warfare, AI expands the legal complexity of warfare. It does not just change what is possible, it changes what is attributable, what is foreseeable, what is controllable, and therefore what is accountable. This series is the systematic attempt to map that change, not in general terms, not in approximations, with the precision that this subject demands and has not yet received. Most intelligent, informed people who follow international affairs closely, who read carefully, who understand geopolitics, carry a fundamental, incorrect mental model of what international law is. They imagine it as a global police force, a supreme authority that issues rules and enforces them on states, a system analogous to domestic law, where a legislator makes rules, courts apply them, and police enforce compliance. That image is wrong in almost every detail. International law is a system of consent-based obligations among sovereign states. States agree to be bound by treaties they sign and ratify. States are also bound by customary international law, which is not a treaty but a body of rules derived from two elements: consistent state practice and opinio juris, the belief held by states that a practice is legally required and not merely convenient or expedient. When both elements are present, the rule binds all states, whether or not they have signed any specific treaty. States create institutions, the United Nations, the International Court of Justice, the International Criminal Court, that have specific, carefully negotiated, and frequently contested jurisdictions. And states retain, as the foundational bedrock of the entire system, the principle of sovereign equality. Every state, regardless of its military power, economic strength, or political influence, is juridically equal to every other state. This architecture was built in its modern form in 1945. The United Nations Charter, signed by 51 states in San Francisco on the 26th of June 1945, is the constitutional document of the modern international order. It was signed 6 weeks before the atomic bombs fell on Hiroshima and Nagasaki. The architects of the Charter were working against the backdrop of 2 world wars. They had just watched the most industrially systemized killing in human history. They built a system designed to prevent that from happening again. The Charter rests on 2 structural pillars. The first is Article 2, Clause 4, the prohibition on the use of force against the territorial integrity or political independence of any state. This is the most important single provision in modern international law. It is not merely a treaty rule. The International Court of Justice confirmed in the 1986 judgment in Nicaragua versus United States that Article 2, Clause 4 reflects customary international law, binding on all states whether or not they are UN members. The second is Article 51, the right of individual and collective self-defense if an armed attack occurs, preserved until The Security Council has taken measures to maintain international peace and security. This is the one explicit exception to the prohibition on force built into the Charter itself. Everything in the law of armed conflict, the 4 Geneva Conventions of 1949, Additional Protocol 1 of 1977, the entire body of international humanitarian law sits within and around these 2 pillars. So now I want to spend a few minutes on the international humanitarian law, IHL, specifically because this is the body of law that governs how warfare is conducted, and it is the body of law most directly challenged by AI-enabled conflict. IHL, it rests on 4 principles, and I want you to understand these not as abstract legal rules, but as operational constraints on the conduct of war. Constraints that make sense when a human commander is making the decision and lose their operational meaning when an algorithm is. First, distinction. Parties to a conflict must at all times distinguish between combatants and civilians and between military objectives and civilian objectives. Only military objectives may be attacked. This is codified in Article 48 of the Additional Protocol 1 and confirmed as customary international law in Rule 1 of the ICRC's 2005 Customary International Humanitarian Law Study, the most comprehensive codification of customary IHL ever produced. Distinction is not a suggestion. It is the foundational rule of targeting law. Second, proportionality. An attack on a lawful military target is prohibited if the expected civilian casualties or damage to civilian objects would be excessive in relation to the anticipated military advantage. Article 51, paragraph 5b of Additional Protocol 1. This rule does not prohibit civilian casualties. It requires that they be weighed contextually in good faith by a commander capable of making a judgment about competing values. Not a calculation, a judgment. Third, military necessity. Only measures necessary to achieve a legitimate military objective are permissible. Force that is superfluous, that causes harm beyond what the military objective requires, violates this principle. This is one of the oldest rules in the law of war, predating the Geneva Conventions, codified in the 1863 Labor Code, and absorbed into every subsequent international humanitarian law instrument. Fourth, humanity. Certain acts are prohibited regardless of military advantage. Torture, humiliation of detainees, collective punishment of civilian populations, deliberate starvation as a method of warfare. So these prohibitions are not conditional on proportionality analysis, they are absolute. Now, and here is the critical question that will drive this entire series. Ask yourself this. Can an AI system operationalize these principles? Distinction requires identifying the status of a human being, combatant or civilian, in conditions of uncertainty, deliberate concealment, and contextual ambiguity. It requires understanding why someone is in a particular place at a particular time. It requires the kind of contextual reasoning that we associate with human judgment, not pattern recognition. Proportionality requires weighing military advantage against civilian harm. A calculation that is not arithmetic but ethical. It requires understanding who is in a building, what the building is used for, what the secondary effects of destroying it will be, what alternative means exist. The ICRC's 2019 technical report on autonomy, artificial intelligence, and robotics concluded that meaningful human control requires not just supervisory oversight, but genuine capacity to understand, intervene, and override, and that this capacity is being systematically eroded by the speed and opacity of AI systems in current deployment. Military necessity requires a judgment about means, not just about targets, but about methods. Is this action the minimum necessary? That is an inherently normative contextual assessment. It is not a pattern matching exercise. And humanity, the absolute floor, requires the moral capacity to recognize a human being as a protected person rather than a data point. To distinguish a victim from a target, that capacity is not a technical parameter, it is a moral one. This is the legal architecture. It was built for a world of human commanders, physical battlefields, and legible causal chains. We are now operating in a world where that has none of those things in their original form. What we have instead is AI. I want to do something now that most legal commentary on AI warfare just fails to do. I want to actually explain what AI warfare systems are, how they work, and what their operational characteristics mean for the legal framework I just described. Because you cannot diagnose a legal problem you don't technically understand. And if your image of AI and warfare comes from science fiction, I need to replace that image with something accurate. Because the actual technology is in its own way far more legally interesting and far more consequentially dangerous than any of those fictions. AI warfare, it is not robots with guns marching across a battlefield. It is a capability layer, a set of computational functions integrated across intelligence, surveillance, targeting, logistics, and decision support operations. Let me give you a taxonomy of how AI is actually deployed in contemporary armed conflict. 6 layers. Each one, it creates distinct legal problems. Layer 1, intelligence, surveillance, reconnaissance. AI is processing satellite imagery at a scale and speed that no human analyst can match. Computer vision systems trained on millions of labeled images can identify vehicle types, weapon systems, troop formations, fortification signatures, and behavioral patterns, and do so in near real time from commercially available satellite imagery. What one took human imagery analysts days of painstaking review now takes minutes. This sounds purely beneficial: faster intelligence, more accurate threat assessment. The legal problem is subtler. The speed and volume of AI-generated intelligence creates pressure on decision timelines that compresses the time available for legal review. When a targeting algorithm has processed 10,000 data points in 2 seconds and produced a confidence rating, the commander receiving that output is statistically less likely to pause and conduct the proportionality assessment that IHL requires. Speed is an enemy of deliberation, and deliberation is what IHL demands. Layer 2. predictive targeting. Layer 2, predictive targeting. This is where the legal terrain becomes genuinely novel and where the most serious documented concerns have emerged. AI systems trained on historical data about behavioral patterns, communication metadata, social network structure, movement analysis, they're all being used to generate target lists, not to identify people who have done something that makes them a lawful target under IHL, to predict what people are likely to do and flag them as targets on that probabilistic basis. This has been reported in depth in the context of active conflicts, including reporting based on accounts from military personnel describing AI targeting recommendation systems. The legal issue here is precise and non-trivial. IHL requires that a person be positively identified as a combatant or as a civilian directly participating in hostilities before they may be lawfully targeted. Positive identification is a present tense determination of current status. Probabilistic prediction, an AI system's assessment that a person has a high probability of becoming a combatant, that is not positive identification of current status. These are different legal standards. The gap between them is not technicality. It is a gap between a lawful strike and a war crime. Layer 3, autonomous effectors. These are systems that can identify, select, and engage targets without real-time human authorization at the moment of engagement. The distinction here is critical and it will drive an entire dedicated episode of this series to come. There is a spectrum of human control from human in the loop, where a human authorizes every individual strike, to human on the loop, where a human can override but is not actively authorizing each engagement, to human out of the loop, where the system operates autonomously within its operational parameters. Most military doctrine, publicly stated, commits to some form of human in the loop. Operational reality is more complex. Loitering munitions, they are autonomous munitions programmed with target parameters and released to find and engage targets within a defined zone. They place the human decision at the moment of launch, not at the moment of engagement. The question of whether that temporal displacement satisfies IHL's requirement for meaningful human control over each targeting decision is not settled law. It is one of the most urgent open questions in international humanitarian law today. Layer 4, electronic warfare and cognitive effects. AI is being used to conduct electromagnetic operations like GPS spoofing, signal jamming, communications interception and disruption that produce physical effects without a single kinetic weapon being deployed. GPS spoofing has been extensively documented in multiple active conflict theaters, producing effects including civilian aircraft navigation disruption and maritime vessel misdirection. These are AI-enabled capabilities. They produce physical consequences. Aircraft diverted, ships grounded, medical equipment losing connectivity, without crossing what most people would recognize as a use of force. Under what legal framework do we assess these effects? Article 2, Clause 4 prohibits the use of force. So, is GPS spoofing a use of force? The Talon Manual 2.0, the most authoritative expert analysis of international law applicable to cyber operations, offers an effects-based framework in Rule 69 The assessment depends on the severity, immediacy, and reversibility of consequences. But this framework has not been adopted as binding law by any state as yet. The effects are often diffuse, cumulative, and deliberately designed to be ambiguous in attribution, which is, of course, the strategic point. Layer 5, Information Operations and Cognitive Warfare. AI-generated content like synthetic media, algorithmic targeted disinformation, coordinated behavioral manipulation of population scale. It is being deployed as an instrument of strategic competition and, in some documented cases, as an integrated component of military operations. The International Committee of the Red Cross has begun using the term cognitive warfare to describe operations specifically designed to target the human mind as a domain of conflict, to shape perceptions, undermine confidence in legitimate authority, and degrade the decision-making capacity of adversary leadership and populations. Protocol 1 of 1977, it prohibits perfidy, acts designed to invite the confidence of an adversary in order to betray it. It prohibits psychological operations designed to terrorize civilian populations. These prohibitions were written for leaflet drops and radio broadcasts. They have no clear application to AI-generated synthetic media deployed through commercial social networks at the scale of millions of simultaneous impressions. The legal gap here is not incremental, it is categorical. Layer 6, Maritime and Space-Based Autonomous Systems. Autonomous surface and underwater vessels, they are being deployed in contested maritime environments, conducting attacks on commercial shipping and military assets in strategically critical waterways. Commercial satellite constellations operated by private corporations providing real-time intelligence, communications, and positioning data are functionally integrated into active military targeting operations, blurring the line between commercial infrastructure and military capability in ways that neither the law of the sea nor the Outer Space Treaty was actually designed to address. 6 operational layers, each one creating distinct legal problems, each one systematically incompatible with one or more of the foundational assumptions of the international legal architecture I have described earlier. I want to say something clearly here, because it is important that you carry it through every episode of this series to come. The legal problem is not that AI is new. The legal problem is not that AI is new. New technologies have always created legal challenges, and law has always eventually adapted. The legal problem is that AI's specific operational characteristics like its speed, its opacity, its scalability, and the diffuse attribution of its effects are precisely structurally incompatible with the foundational assumptions on which international law's regulation of warfare is built. This is not a bug in the AI systems. It is not a design flaw that better engineering will correct. It is a feature of what AI is, of what makes it militarily valuable in the first place. That means the legal problems cannot be solved by tweaking existing doctrine. Some of them will require new doctrines. Some may also require new treaties. But some The most troubling ones may not be solvable within the current architecture of international law, without that architecture being fundamentally reconceived. Those are the problems this series is going to examine. So now I'm going to walk you through all 20 of the legal fault lines that this series will examine. Each one is a place where AI warfare and international law collide. Each one has a dedicated episode of depth, analysis, and precision. What I want to do here is give you the conceptual landscape, the map, so that when you enter these episodes, each one of them, you understand not just what the episode is all about, but where it sits in the larger architecture, how it connects to what came before and what comes after, how the whole series builds systematically towards a single argument about the future of international law. We begin where all of international law begins. Yes, you're right, with sovereignty. Because if sovereignty itself cannot be defined in a world where a targeting algorithm crosses 5 borders in a single second, then nothing built on top of it holds. And once sovereignty fractures, the next question arrives immediately. What does the prohibition on force even mean when the most consequential acts of state aggression leave no physical mark, no crater, no visible wound, only a power grid that stops, a financial system that freezes, a population that suddenly cannot trust what it sees? If that threshold is genuinely unclear, then so is the right to respond to it. And so the question of self-defense becomes urgent in a way it has never seen before. Because the window in which a state can lawfully act in its own defense is now measured not in hours but in seconds, compressed by systems that can decide faster than any human chain of command can deliberate. But compressed timelines also mean compressed accountability, and so we are forced to ask, when an AI system produces the act, who is legally responsible for it? Is it the state? Is it the commander? Is it the corporation? And the moment we try to trace that responsibility, we arrive at the targeting decision itself, the single most legally consequential act in warfare. And we find that the principles that are designed to govern it, like distinction and proportionality, they were written for a human being standing at a decision point, not for an algorithm processing 10,000 variables in 2 seconds and producing a confidence score. That algorithm will classify people. And so we must ask precisely who a civilian is in a conflict, whether software engineer, the satellite operator, the data labeler, the logistics coordinator. They are all functionally part of the strike chain without ever holding a weapon. And the infrastructure those people depend on, the power, the water, the communications networks, the undersea cables, becomes a battlefield in its own right, attacked not with missiles but with code, producing human civilian harm that cascades silently across borders and into states that are party to no conflict at all. Which raises the question of what neutrality means when simply hosting a cloud server or routing a packet, it makes a state complicit in someone else's war. So to answer that question honestly, we cannot rely on doctrine alone. We must look at the operational evidence, the documented systems, the real deployments, because legal analysis divorced from operational fact is not any analysis at all. And when we look at that evidence, the question of autonomous weapons becomes unavoidable. Not whether they exist, but whether they can ever be lawful. And who bears criminal responsibility when they are not, given that command responsibility was built for human subordinates and has never been tested against a machine that no single human being fully controls or fully understands. That opacity, the black box at the center of every AI decision. is what makes information warfare so legally unprecedented. Because when synthetic media and algorithmic disinformation, they become instruments of conflict. The law of perfidy and psychological operations has nothing to say about them, and the multilateral institutions that were supposed to produce new law have spent a decade in discussions and actually produced nothing binding, which forces us toward the deepest question of all: whether accountability itself is legally sustainable when causation cannot be traced, when the control of the instrument is genuinely distributed across developers, deployers, exporters, and commanders, none of whom made the final decision. That question becomes existential when the instrument is nuclear. When AI compressed early warning timelines, they remove the deliberation that nuclear weapons law demands, and it becomes concrete when we name the specific systems, the documented deployments, the corporations whose design choices are already producing legal consequences in active conflicts, whose export to foreign militaries raises liability questions that ITAR and Wassenaar arrangement they were never built to answer. And the battlefield is not only on land, it is also on the sea, where autonomous surface and underwater vessels are attacking commercial shipping in internationally designated straits under a law of the sea that has no provision for uncrewed warships, and it is in space, where commercial satellite constellations are functionally integrated into military targeting operations under an outer space treaty that was written when no private company had ever launched anything. And it is in every occupied territory on Earth where AI facial recognition and behavioral prediction systems are being deployed against protected civilian populations under a Geneva Convention that was written for a world where occupation meant soldiers at checkpoints, not algorithms tracking every face, every movement, every connection in real time, without limits, without appeal, and without a legal framework capable of stopping it. These are the questions this series will answer. Not approximately, not in outline, in full. 20 fault lines, 20 episodes. One argument built systematically across 20 hours of analysis. I want to close this map episode with something I do not want you to forget. Not in episode 1, not in episode 20, not after the series ends. The question of AI and international law is not an academic question. It is not a question for lawyers or for engineers or for diplomats working in Geneva. It is not a question about the future. It is a question about right now. Right now. There are people living in cities where AI targeting systems are generating strike coordinates. Right now, there are people living under occupation where AI surveillance systems are tracking their movement, mapping their social connections, and predicting their behavior. Yes, right now there are undersea cables and power grids and financial networks that AI-enabled operations could disable within minutes, and whose disruption would affect hospitals, schools, water treatment facilities, emergency services in countries not party to any conflict. The law that was supposed to protect these people was written before these technologies existed. The institutions charged with enforcing that law were designed for a world where states were the only significant military actors, where force was physically legible, and where a human being made every decision that mattered legally. That world did not end gradually. It ended operationally when AI targeting systems were integrated into active strike chains, and when autonomous munitions they were released into contested airspace without real-time human authorization over each engagement. Whether it ends legally, whether the international legal order adapts, is not predetermined. It depends on the quality of analysis brought to bear on these questions, on the precision of the legal diagnosis, on the willingness of scholars, practitioners, policymakers, and the engaged public like you to look directly at what is happening and say, this is not what the law permits, and here is exactly why. I want to close with a sentence from Paul Schar's Army of None, because it is the most precise single sentence I have encountered about what is actually at stake. Share rights. The question of autonomous weapons isn't simply a question about technology. It is a question about what we value as human beings. I would add one dimension to that. It is also a question about what kind of law we are willing to build, because the law we have, the law of 1945, of 1949, or of 1977 was not built for this. It was built by people who had just watched the worst war in human history and were determined to prevent another one. They built the best architecture they could with the understanding of warfare they had. So we now have a different understanding. We have a different and far more dangerous technological reality. And the choice we face is not between the old law and no law. It is between building new law deliberately, rigorously, with the depth and precision that this moment demands, or accepting a world in which the conduct of warfare is governed by the speed of algorithms, the opacity of machines, and the accountability of no one. So this series is an argument for the first option. I will see you in my episode 1, Sovereignty in Fragments, Territorial, Digital, and Cognitive Control. You are at the AI Law, and I'll see you soon.